So imagine this situation. There are three friends decide to launch a startup. They finalize an office space, they negotiate with the suppliers, they hire the employees, they purchase the software subscriptions, they even place the orders for laptops and equipments. But there is one problem. The company has still not been incorporated legally. The company does not exist yet. So now a very important question arises here in this case is that if these agreements are being signed before the company legally comes into existence, then who is actually bound by those contracts? Will the future company be liable? Will the promoters become personally liable? Or will the contract itself become unenforceable? And this entire issue is what we are going to study under the concept of pre-incorporation contracts. Let's begin. So pre-incorporation contract, as a name suggests, simply means a contract entered into before the incorporation of a company by promoters or other persons on behalf of the proposed company. So in simple words, these are the agreements that are made for a future company before the company legally exists. Now you may naturally think that why don't actually promoters simply wait until the incorporation is completed? Because in practical business life, waiting is often not possible. Okay, so businesses may need all these things even before the incorporation is completed, and many commercial opportunities are very time sensitive. So if promoters wait for all the legal formalities to finish first, the opportunity itself may disappear. And that is exactly why the pre-incorporation contracts have become commercially necessary, especially in the modern startups and the fast evolving or fast moving businesses. Now, this entire topic revolves around one core legal problem. Under the company law, a company becomes a separate legal person only after the process of incorporation is completed. Only after the certificate of incorporation is issued does the company get its own legal identity. Now, before incorporation, the company is merely an idea or a proposed business structure. In the eyes of law, it is not yet a legal person, and because it does not legally exist, it cannot enter into contracts, appoint the agents, own property, or undertake legal obligations. Now, this immediately creates a major difficulty. So, if a company itself does not exist, then how can someone enter into a contract on its behalf? And this is where the law of agency becomes very important, because under the agency law, an agent acts on behalf of the principal. But for a valid agency relationship to exist, the principal itself must already exist in law. An agent cannot represent a non-existent person. So in pre-incorporation contracts, promoters technically cannot act as agent of the company because the company itself does not exist yet. So this very principle is known as the doctrine of non-existent principle. Now this also creates another major problem relating to the ratification. Normally under the agency law, a principal may later approve the acts which were done by the agent before. Now, once ratified, the act is treated as valid from the very beginning, but the ratification is possible only when the principal existed at the time of the original transaction. And in pre-incorporation contracts, the company did not exist when the contract was entered into. So therefore, under the strict common law principles, the company cannot later ratify the contract in the true legal sense. So under the traditional English common law, the position was extremely strict. A company could generally neither enforce nor be bound by a pre-incorporation contract. So naturally, another question arose that if a company cannot be held liable, then who will actually be liable? So very often the liability shifted to the promoters who actually entered into the contract, who actually signed the contract with the third parties. This was mainly done to protect the third parties, because otherwise the contracting party may be left without any kind of legal remedy. Now imagine that there is a supplier supplying goods believing that the future company will actually make the payment, but later if the company says that we were not legally in existence when the contract was signed, and promoters also deny the liability, then the supplier would be left completely remediless. So courts here generally try to avoid such situations where the contractual obligation exists but nobody can be held legally accountable, and therefore in many situations promoters were also treated as personally liable. Now the leading case on this topic is the famous English case of Kellner versus Baxter. So this is one of the most important cases relating to the topic under the common law under this topic. Okay, and this case established the principle that promoters may become personally liable for the contracts which are entered into before the incorporation. So in this case, the promoters of a proposed hotel company entered into a contract to purchase the wine for their business that they are going to use. But at the time of the agreement, the company had still not been incorporated. So later when the company was incorporated and the wine was actually consumed and used by the business. However, before payment could actually be made to those suppliers, the company went into liquidation. So the seller sued the promoters personally for the payment. And the main issue before the court here in this matter was that can the promoters be personally held liable for the contracts made on the behalf of the company that did not exist at the time of the contract. So the court held that the promoters will be personally liable, and the reasoning was very simple, that since the company did not exist when the contract was made, the company itself could not have been the contracting party clearly. So therefore someone had to bear the liability, bear the loss that the third parties are facing, and the persons who signed the agreement were treated as personally bound in this matter. So basically this case established three important principles. The first principle was that a company cannot be bound before the incorporation because it had no legal existence at the time of contract. Second principle was ratification after the incorporation does not automatically validate the original contract under the common law. The third principle is promoters may become personally liable where the contract on behalf of the non-existent company. But over time, this strict common law approach started creating very practical commercial difficulties, because in real business life, many arrangements simply cannot wait for the entire process of incorporation to be completed, and therefore several legal systems, including India, gradually adopted a more practical approach that can actually fit into the modern business world. Now, one important thing to remember here is that the Companies Act 2013 does not comprehensively regulate the pre-incorporation contracts. The major recognition under the Indian law comes from the Specific Relief Act 1963, and these are the two important provisions which allow the limited recognition of certain pre-incorporation contracts after the incorporation of the company. So in simple words, where the promoters are actually entering into a contract for the purpose of the proposed company, and the company later accepts that contract after incorporation, the contract may become actually enforceable. And this is a major departure from the strict common law. So under the common law, the company could neither enforce the contract nor be bound by it. But in Indian law, it recognizes that the commercial transaction cannot always wait for the entire process of incorporation to be completed. Now at this stage, one important conceptual question arises, that if the company later accepts the contract after the incorporation, does that amount to ratification? Legally, the answer is no, because ratification requires the principle to exist at the time of original transaction, and the company did not exist at that stage. So technically, this is not ratification. Instead, Indian law recognizes adoption, acceptance, or even the recognition of the contract after the incorporation. So this distinction is extremely important, because under ratification, the law treats the act as valid from the very beginning, but under the adoption, the company becomes bound because Indian law permits post-incorporation acceptance under the statutory recognition. Now, even after understanding the adoption, another important question that still remains here, that if the company was not originally bound by the contract, then what happens to the promoter who signed it? This brings us to the important concept of promoter liability, and this is one of the most practical and commercially important parts of this entire topic. So promoters are usually the persons who negotiate the contracts, arrange the infrastructure, deal with the suppliers, and handle the early stage business arrangements even before the entire process of incorporation of a company is completed. And because the company does not legally exist in the eyes of law, at that stage, promoters in many situations become personally liable as well. And this becomes especially important where the company never gets incorporated at all. The company refuses to adopt the contract that was signed by the promoters earlier, or the agreement itself imposes personal liability upon promoters. And this very issue has become extremely important in the modern startups, because founders today often sign office lease, hire employees, purchase softwares, and do a lot of other activities even before the entire incorporation process is completed. So if these arrangements are not properly regularized later, founders may unintentionally remain personally liable as well for the acts. Now, although adoption provides statutory recognition, but commercial practice often prefers an even safer method, and that method is called novation. So novation means substitution of a new contract in the place of an earlier contract. So in pre-incorporation contract situations, novation usually works like initially the promoters enter into the contract before incorporation. Later, after incorporation, the company enters into a completely fresh agreement with the third party. So this new agreement replaces the earlier arrangement, and from that point onward, the company actually becomes the direct contracting party. This is often preferred in the commercial practice because it creates clearer allocation of liability and reduces the disputes regarding the promoter responsibility. You might also confuse adoption with novation, but both are conceptually different. Under adoption, the company accepts or recognizes the earlier arrangement after the incorporation process. The earlier contract substantially continues, but under novation, a completely fresh contract replaces the earlier arrangement. So in adoption, liability arises through statutory recognition and acceptance, but in novation, liability arises from a new agreement, a completely new agreement itself, and therefore novation is generally providing greater legal certainty in the commercial practice in the actual corporate world. Now, one important thing to remember is that the Indian law does not automatically validate every pre-incorporation contract. Sections 15H and 19E apply only when the certain conditions are satisfied, and these conditions are very important both from examination perspective and the practical corporate law perspective. So the first condition is that contract must be for the purposes of the company itself at all times. So the contract must genuinely relate to the future business of the company. In simple words, the agreement should be entered into for the benefit of the proposed company and not for the personal purposes of the promoter. For example, if the promoter purchased the machinery for the future manufacturing business, the condition is actually satisfied. But if the promoters enter into a purely personal transaction and later tries to shift that liability to the company, the protection will not apply. Second condition, contract must be within the objects of the company. So the agreement should also be consistent with the intended business objects of the company, and the contract should reasonably relate to the nature of the business, the incorporation document, and the operational purpose of the company. So this condition prevents misuse of the corporate identity for unauthorized obligations. Third condition is that the company must accept the contract after the incorporation. So this is the most important requirement out of the three conditions that we just discussed, that after incorporation, the company must accept, adopt, or recognize the contract. Without post-incorporation acceptance, the old common law difficulties continues, and in such situation, promoters may also continue facing the personal exposure. So ultimately, the law relating to the pre-incorporation contracts represents a balance between the strict legal theory and commercial necessity. And from a strict legal perspective, a company cannot contract before the incorporation of the company because it does not legally exist. But from a business perspective, many important commercial arrangements cannot realistically wait for the entire incorporation process to be completed. Indian law therefore adopts a more practical approach through concepts like post-incorporation adoption, statutory recognition, and novation, and that is the legal framework governing the pre-incorporation contracts under the ambit of company law.